Have you ever wondered how workplaces keep up with our ever-changing laws, especially when it comes to something as dynamic as cannabis regulations? It can feel like a moving target, right? Well, good news for California employees. As of January 1st, 2024, California implemented a new law, Assembly Bill 2188, which significantly restricts an employer's ability to discriminate against workers based on their off-duty, off-premises cannabis use. This means a major shift in how companies approach drug testing and employment decisions. The why behind this change is rooted in recognizing the difference between active impairment and past cannabis use. The law aims to protect employees who legally use cannabis outside of work hours, away from the workplace, and who are not impaired on the job. Traditional drug tests often detect non-psychoactive cannabis metabolites, which can remain in a person's system for weeks, long after any impairing effects have worn off. This new legislation focuses on preventing discrimination for non-work-related use that does not affect job performance. So, what does this mean for you as an employee or for businesses in California? Employers can no longer use drug tests that identify only non-psychoactive cannabis metabolites for hiring, firing, or other employment decisions. Instead, they must utilize testing methods that identify the psychoactive compound, delta-9 THC, indicating recent cannabis use and potential impairment. This shifts the focus from simply detecting past use to determining if an individual is currently under the influence while on duty. However, please remember that this law does not permit employees to possess, be impaired by, or use cannabis on the job. One interesting detail about this law is its explicit carve-out for specific industries. For example, it does not apply to employees in the building and construction trades or to positions that requiring a federal background check or security clearance, such as those governed by Department of Transportation regulations. This nuanced approach recognizes that safety-sensitive roles have different requirements, ensuring public safety remains a top priority. Additionally, employers are still permitted to maintain a drug and alcohol-free workplace policy and can take action if an employee is impaired at work. Understanding these updated employment drug policies means you are better equipped to navigate the modern California workforce with confidence. It empowers both employees and employers with clarity, fostering a fairer and more informed approach to cannabis use in a state where adult recreational use is legal. This positive step helps ensure that personal choices made responsibly, outside of work, do not unfairly hinder career opportunities.